Rory, let's see. I'm glad to be back because this year is a little bit different than prior years. Because in prior years we had a crowd of people, and the system was like when we saw people, we would insist they come into the office. And nowadays, instead, things are done remotely. So in a way, it becomes more efficient and easier for people. But still, people ask the same questions. Well, why do I need to have a will if I'm married? Doesn't everything go to my spouse? He goes, well, no, under New Jersey law, no, not everything goes to the spouse. If there's no kids, it could go to parents. If there's kids from prior relationships, it gets divided. And but even if uh, there's the same children from the same relationship, uh, the idea is try and make things as easy as possible for your family. So if there's no will, or if the will was declared to be invalid because it was improperly prepared or improperly signed, for a lot of sometimes people do these like cheap things online, and then they can't be admitted to probate by the county surrogate. So, but if it's there's no will, the procedure to distribute assets becomes much more complicated. It requires all the children to sign to select someone to be the administrator. Then all the children have to sign a formal renunciation affidavit in front of a notary. Then that has to be filed for a fee with the county surrogate. Well, let's say one of the kids doesn't sign this renunciation affidavit. Then that requires that one of the family members has to file a complaint order show cause to Superior Court, New Jersey, then have everyone signed, and then have a hearing before a judge to become the administrator. So they're looking at a cost of over $3,000. Well, certainly a $400, $500 will would avoid that expense. Number two, there is other additional expenses and extra work if there is no will or it's not admitted to probate. So, for example, New Jersey law says there has to be a surety bond taken out by the person who's the administrator if there's no will. Well, surety bond company, it's like an insurance policy, but they could charge $1,000 a year. Again, additional costs, additional expenses, additional legal fees. Three, state law determines who gets their assets if there's no will, not you. And a lot of times nowadays, people, you know, you know, don't say no. I'm not going to leave it equally to all my kids, not because you don't care about one kid more than the other, but sometimes one kid may need it more often. Sometimes people might say, I'd rather leave it to my grandkids because they're going to need it for their college, rather than leaving it to one of their own kids that would say, hey, I'm going to go buy a boat and have my kid not go to college. So the other, if you don't have a will, conceivably people that don't care about you, haven't been in your life, could inherit your money. If there's minor children, a stranger in New Brunswick determines who gets custody of kids. That's the surrogate judge. Certainly, most people could think of well, who don't they want to be the guardian of their kids if something happens? You lose the opportunity to possibly reduce any taxes. But more importantly, if there's no will or the will was not properly done and can't be admitted to probate, it often causes aggravation, fights, sometimes lawsuits amongst the family. So when the family is grieving, dealing with death, there shouldn't be one more thing they have to deal with. They shouldn't be overwhelmed with these financial issues, concerns over having the estate. So the whole idea is do some planning and get things done. No one would decide on a Thursday afternoon, you know what, I know I have my vacation starting on Saturday, and I haven't planned where I'm going to go or what I'm going to do. Yeah, you do some planning ahead of time. So think about who don't you want to get your assets, who would not be the best person to raise children. Do you want what age do you want children or grandchildren to get money? You don't want kids or grandkids that are 18 getting money. But 18-year-old invest money wisely. Now, also, I always tell people beware of these cheap online forms that you find. I'd say because a lot of times people don't do them right, and it ends up costing more money. So doing your own electrical work is very foolish. Trying to do your own plumbing work, if you don't do it right, you're going to have sewage throughout your house. And so have a professional do it right. Have an attorney that knows what they're doing. And also, if you already have a will, make sure that it's a self-proving will under the revised New Jersey laws, and it says no bond is required. And we're going to get into that during the program briefing. So, logistically, what last year will be? Let me go back. Before March of last year, we would always insist that everyone come into the office, make an appointment, take off time of work, and drive. Well, when COVID hit, everything was closed, surrogates was closed. So in a way, we made it more efficient, easier for people to get their things done so they don't have to be put or offered. So to assist potential clients and seniors, we now do the document preparation without people having to come in. We're concerned also about people's health and well-being and people not breathing on each other. So for the wills, power of attorney, living wills, we simply email out the interview form, and then they type in their name, who's executor one, who's executor two, and who's getting their things. And if that person passes away, who would get it? They type it up, they save it, and they send it back to our office. I call, I'm in the car with that hands-free thing, calling people all the time. Originally we were trying to do the consults through Zoom, and then I found a lot of people didn't want to do Zoom one-on-one because that meant that they had to look nice. They didn't want to, and a lot of the people just wanted to have their T-shirts on. So they say, hey, telephone is fine. Telephone is fine. So we prepare the documents. We email out. Interestingly, when the state was closed last year, the UPS stores were open, and the UPS stores were notarizing documents. Even the banks were closed. So for a small fee, the UPS stores would notarize documents, and everything was done. So it's important to get these documents done. So we strongly recommend adults have a will, power of attorney, and a living will in the event that they're temporarily incapacitated or hospitalized. On the other hand, like what happened during COVID. Well, people were saying, well, I need to get a document for mom, dad, or Uncle Joe because they're in a hospital, they're sick. Well, we can't do a document for someone that we can't speak to. That's not permitted by the New Jersey ethics laws. I got to speak to someone and make sure it's what they want, not what their family wants. I mean, sometimes what's in there, what they would probably want, but that's not good enough. I need to talk to the people, and they need to tell me what they want. So the whole idea is not be a putter off. We have so in the will questionnaire, again, it asks simple questions. Okay, we email it out, not that complicated. Let's say, hey, who's going to be? What's your name? Who's executor one? Who's executor two? Now, we strongly tell people do not have joint executors. That is foolish. If you have joint executors, you're creating twice as much work. That means that two people have to, go to the surrogate's office and fill out surrogate papers. Then two people have to meet with a realtor to sign a contract, the listing. And two people have to sign a contract for sale. Two people have to sign an addendum. Two people have to sign every single check. Two people have to go to the real estate closing. Why create twice as much work? And now there's a reason why there's only one president of the United States at a time and a vice president. There's not co-presidents. So you don't want to have co-executives. The car has one steering wheel, not two steering wheels. So don't have joint executives. We want to have things as easy as possible. So the questionnaire, we used to ask a lot of questions about what people's assets were, but New Jersey then did away with the New Jersey estate tax. So there's only an estate tax when it's more than $11.7 million. And not that many people I know in the Woodbridge Edison area have $11.8 million. But also keep in mind that the will takes care of your assets that do not have a beneficiary. Certain things have direct beneficiaries, and a will can't change that. So examples of that are if a house is owned husband and wife, automatically goes to the surviving spouse. A will can't change that. Let's say if the house is owned what's called joint tenancy, let's say a parent owns it with a kid, automatically goes to the survivor. The will can't change that. Bank accounts that are POD, joint tenancy, payable upon death, automatically go to the survivor. A will can't change that. People have CD sometimes. Again, a CD, if it's like, payable upon death, goes to that person. Now, other assets passed by way of contract. IRA, 401k, life insurance, annuities. If there's a private, pension plan, a will can change that. So any items that have a direct beneficiary, make sure that I recommend people get the printout, and then after they do their documents, they put it in their folder that has their will and other documents. So then you get into who's going to be the beneficiary, it's people's right to determine who's getting their assets. I had a client that says, one of my kids, we don't hear from much, and do I have to leave something to him? I go, okay, let's see. On Christmas, did you get a card or a call? She goes, no. On your birthday, did you get a card or a call? No. On Mother's Day, did you get a card or a call? No. So why should you leave the person anything? If they don't care if you're alive, that kind of person, the one that wasn't around, is going to be the biggest mouth after I said you pass to say, where's my money? Where's my money? Where's my money? Now, the will should always direct, if someone passes away, who gets their share. Now, more and more people are saying, again, I'm not going to leave it directly to my kids. I'd rather leave it to my grandkids, because they're going to need the money for going to a better college and investing in their future. You leave it to some of your kids, and they'll just buy a sports car. Now, in addition to the general who's getting stuff, many people have what's called the specific bequest. What a specific bequest is, it's setting forth who would be getting a certain asset. So sometimes the ladies say, I want my jewelry to go to my granddaughter. Some of the gentlemen say, I got firearms, I want it to go to either a son or a family member that has firearms that is a sportsman. Some people say, I want a specific bequest, some money going to a charity, to a nonprofit, etc. So X amount of money to St. Cecilia's Church, X amount of money to St. Thomas High School, X amount of money to their temple, whatever someone wants. Now, in addition to specific bequests, sometimes people have what's called the reverse specific bequest, meaning I leave nothing to name a person. We don't put a reason, we don't give them $1, nothing to them. But you should always have a clause that says what age someone might get something, because we don't want 19-year-olds getting money. 19-year-olds don't do smart things with money. They go to Seaside and buy beer. And if a 19, 20-year-old was going to inherit money, they get also influenced by their friends as to where they should spend it. So if someone says, I don't want my kids to get the money till they're 30, but the money can be expended for their health support, maintenance, college, grad school, whatever, hey, that's fine also. So that's what some people do. If there's minor children, you want to set forth who would hold their money until the age. Typically, we set up a trust for minors in the will where they get some money when they're 22, 25, and then 30. The trustee holds the money. The guardian is the person who holds the kids. Some people put off, well, I can't really decide. It's so difficult. And when I tell people, because, okay, let's say you couldn't leave your house tomorrow, or let's say you couldn't come home. Who would you want to watch your kids for the next 2 weeks? You think, my father. Okay, that's the person, or your mom. Well, they say they're getting older. Yeah, but the idea is who would be the best person now, and also who don't you want? Because if you don't have a person set forth, then a stranger doesn't. If the will does not have a clause that says no bond required, has to take out a bond, and these cheap forms online don't say that. Also, you want to have a self-proving will that dispenses with the requirement of finding witnesses down the road. My office does self-proving wills. I know that there was an office that was in northern Middlesex County. They would intentionally not do self-proving wills, so the family used to have to go and find the the law office, and then have to pay them to do it. So I tell people, listen, if I do it, I'll do it right. If you do it, well, how do you know you're doing it right? And attorneys don't look at something that someone did themselves. Now, logistically, when the document is signed, the original will is your property. That's your property. It's not the attorney's property. The attorney doesn't keep it. Wills are not filed anywhere until someone passes. So most people buy a fireproof box. They put it in the fireproof box, and it stays there until like someone passes away down the road. Not that complicated. If you can't find the original will, get a new one done. My rule of thumb is if you can't find it in 72 hours, don't be a putter offer. Get the stuff. Get something done again, because like the whole idea is to try and make it as easy as possible for your family, so they don't have to worry about one more thing. The original will. Some people put in a fireproof box. Some people give it to who their executor is. Now, who should be the executor? Well, again, the rule of thumb is it's someone who should be able to drive to a bank and walk up a flight of steps. We are not, trying to say don't pick a spouse who's older, but we want to be practical. Is the whole idea of the executor or the person, the power of attorney, is they have to be able to do the job. They can't do the job if they can't drive and get around. They can't do the job if they're blind. Very different. So the idea is get two people that can do it right. Some people don't have relatives in the U.S. The executor can be someone in another country, preferably someone who speaks and reads English. But that's where that's done. Also, it's important that people prepare what's called a letter of instruction. It's not a legal document, but you're telling if your executor is not someone who lives with you, where your stuff is at, and also make sure they have access to your house. Do not write this down. Do not leave the stuff in a safe deposit box. Can't get it on a Friday. Can't get it on a weekend. And what happened last March when the state of New Jersey closed? You couldn't get into a bank. So if you had your stuff in a safe deposit box, and all of a sudden you needed something, tough luck. Some people have kids with special needs that they would need a special needs trust. Logistically, typically we do wills for a basic will for a flat fee of about $400. I tell people it's an investment. We do it right. That's what are the clauses in the will? Debts and taxes paid, distribution to spouse, sometimes a trust to a spouse. In second marriages, rather than leaving money outright to the spouse, we set up a trust within the will. Sometimes we set up trust for a kid that's over 21, over 30, but they got issues. They could have financial problems. They could have substance abuse problems. They could be a slacker. And you don't want to give someone who's an alcoholic, $100,000 because they'll spend it on booze and give it away. We want to protect them. Your clauses are who your beneficiaries, when the beneficiaries get it, who's executor one, executor two, who's the trustees. You want a clause that says no bond required. And also I mentioned having what's called the self-proving will. So that is important. Oftentimes people, my mother-in-law used to call me every other year, say, I want to come in and get a trust done. And I would ask her, I goes, were you watching Susie Orman? She says, oh, yes. I said, well, Susie Orman is exactly right if you live in New York, California, Florida, where probate is very complicated. But New Jersey's the probate easiest state. So, people says, I want to get a trust done. I ask them, well, why do you want to spend between $3,000 and $6,000 doing trusts when probate in New Jersey is easy? A revocable trust does not protect assets from nursing home. It doesn't protect assets from creditors. It doesn't protect assets from taxes. The only thing a revocable trust is on the way that when someone passes away, the trustee can act right away. But otherwise, sometimes what's the rush? Because, it only takes, usually about 12 days to go through our whole probate process. There is a thing called an irrevocable trust. So that's something that's done to shield assets in case someone has to go into a nursing home. But that means the assets are retitled. So if someone owns a house, they don't own it anymore. It's owned by the trust. They have assets, not going to be owned by them. It's owned by the trust. They're not the primary trustee. They can't have control. So, again, if someone says, listen, I want to do everything possible to protect my assets in case I got to go to a nursing home. Okay, fine. That's an irrevocable trust. You're looking to spend like, 4 or 6 grand. But that's something that is done. On our website, njlaws.com, we have more information on wills, revocable trust, also known as living trust. And again, it's what's best for people. Oh, and by the way, before I go into our next topic, which is powers of attorney, we typically charge a consult fee of $200. But if someone contacts us within the next 30 days by April 17 and says, listen, I want to do the consult and fill out the form, then we don't charge the people the $200 consult fee. So think about that, write that down. Okay. So now let's get into what is a power of attorney? What's this power of attorney thing? Well, a will takes care of your assets if you pass away. A power of attorney takes care of your assets if you become disabled or now. So it's very, I tell people, even married people, in a way, having the power of attorney is more important than the will. He goes, why? He goes, well, listen, you guys are married, you have 2 kids, same marriage, your wife automatically gets everything. But if you fell down and clunked your head and all of a sudden you're in the hospital, your spouse doesn't have the legal right to do that much because it's not in writing. So the whole idea is have it in writing, have it done properly ahead of time. Let's see. So with the will, the power of attorney, you're giving the power to someone that you trust to be able to make sure your bills are paid and sign on your behalf. The will is either effective right away or only upon disability. A power of attorney that's effective right away is called a durable power of attorney, meaning it's in effect now, it's durable, it stays in effect even if someone becomes disabled. A springing power of attorney only springs into effect if someone becomes disabled and there's a certification under a state statute by a doctor that the person is disabled. So most people make it effective right away, so they don't have to go through the whole doctor thing, because a lot of banks make it much difficult. Well, I don't know, this is only effective upon disability. How do we know the person's still disabled? How do we know the doctor's certification is good? So, probably 85% of the people said, listen, I'm making it effective right away. One of our clients said, listen, Kenny, you got to explain this in my language. She goes, I'm a carpenter. I don't understand this legal springing and durable. So please explain to me in carpenter terms about this power of attorney. So, okay, Fred. If it's effective right away, your son, who is the power of attorney, can steal all your money right away. If it's effective only upon disability, your son needs to get a note from a doctor before stealing your money. Let's see. Having said that, do you trust your son? He goes, I trust my son with my life. Well, then make it effective right away. And by the way, I'd say, people call me up and or we used to have meetings with people and they say, I want to read up on this. I goes, listen, you don't need to read up on anything. Let's see. The whole idea of this, I went to law school. I do seminars for the state bar, for the American bar. I've written a book. I've done all your reading. When I needed to have knee surgery, I didn't read anything at all about knee surgery. I asked the good doctors at University Orthopedics. He goes, doctor, have you done this kind of surgery before? He goes, Kenny, I've done 1,000. It's okay, good. Do the best you can. Thank you. Let's see. I don't want to know. So don't put it off. Don't say, oh, I want to read more up. Just let the professional do it. You don't need to read up on all this stuff. And because they did away with the taxes, you don't need to do all the study. Some time ago, there was a older gentleman, and I went over all the stuff I recommended for him, and he goes, "Oh, it was an old school guy. I want to read up on this." Okay, follow up, doesn't follow. 2 years later, the family goes, "Okay, Carl died. We saw some your business card. Do you have his will?" No, he wanted to keep on reading. Let's see, didn't get the documents done. So again, let's try to get the documents done. You don't need to read up on this stuff. I've read it for you. And by the way, of one of my clients says, "Don't you need to know more about your stuff or meet with me?" I go, "No. Let me ask you a question. You're married. Are you looking to disown your wife?" "No, I want my wife to get everything." "Okay, good. You have kids, right?" "Yes." How old's the youngest?" He goes, "The youngest is 30. Okay. Are you looking to disown any of your kids?" "No." "And it's a first marriage, right?" "Yes." I said, "Listen, Mr. P, I know what you need more than what you need, because this is what I do for a living, honestly. So again, I will do it right. Now, let's go back to the power of attorney thing. The power of attorney, you're given the power to be able to, for real estate. Even we updated it to have access to medical records, to make decisions under pulse, to sign contracts, and most importantly, to access bank accounts, CDs, money markets, etc. So I'd say, however, a lot of times back then, the banks used to give people a hard time. So the New Jersey legislature came up with a statute that says, and it makes reference to the New Jersey statute, if they do work in New Jersey, the banks or institutions have to honor it. However, statute, which is Section 2 of PL 1991 C95C 46:2B-11. And I'm pretty sure these cheap things that I see online or people try to find online don't make reference to a Jersey statute. And then someone all of a sudden gets ill, and it doesn't have the proper language, and they can't act on it. So don't assume just because you read, if something says that you bought online, it's valid in every 50 states. Well, if it's done wrong, maybe you'll get your $20 back. Now, I mentioned the original will is your property. You make sure it's in a safe place, or the executor has it in a safe place. But only the original will can get admitted to probate. It's not filed with the courts until someone passes. So a photocopy of a will cannot be admitted to probate. Let's see. With a power of attorney, many banks and institutions will honor it. So what we've been recommending people is, after they sign their power of attorney, that they scan it, and it's emailed to themselves, to their financial advisor, to their banks, where life insurance companies, wherever they have assets. So it's on record that it's there, so that down the road, if your agent calls them up, it's not a surprise, and it becomes less work. And the financial advisors appreciate that, because they know it's someone extra they can talk to. So number one, have your will done, or your trust if you're inclined. 2, have your power of attorney done, and then make sure that the power of attorney is then forwarded to the different important entities that you have. All right. And also on the website, NJ Laws, there's more information on powers of attorney. Now, a will that's done now is good 20 years from now. as long as it still contains what you want. So it's a good idea that, every 5, 10 years, you take out your will and says, okay, is this still how I want to get my stuff? Yes. Is there anyone I want to take out? Yes or no? Can my 2 executors still do the job? You could have picked someone as the executor in 2021, but 5 years from now, they're no longer in your family, or they had a stroke or can't do it. Well, then you don't want to wait till it's too late to do stuff. We get calls all the time. Oh, I need to get power of attorney over mom, dad, or Uncle Joe. Can't do. That person got to firmly tell us what they want. If they're in the hospital and they are disabled and can't talk to us, can't do a document, especially someone who's, is not awake, not competent. Now, a will does not need to be updated. However, we are now recommending that people sign a new power of attorney every 5 years. The reason why is because some of these banks or institutions would, they will look at somebody that's 10 years old. He goes, well, how do we know this is still in effect? Also have a new power of attorney if the people's addresses in the document have changed or their names have changed. It doesn't invalidate the power of attorney, but let's say your daughter is the person you picked for your power of attorney, and then you have a medical issue. You're in the hospital, and they go to try to pay your bills, and at the bank goes, well, who are you? Goes, well, I'm Joe McDermott's daughter. I have Joe's power of attorney. Okay. They goes, well, you're not this person. You're someone else. Well, I got married or I got divorced. This is my new name. Well, and this is a different address. How can we know this is the same? So it's a good idea to have. And I also mentioned the word divorced. If someone is separated, it's important to rush out. And if you already have a power of attorney, get a new one done. Otherwise, you're giving the power to your soon-to-be ex to loot your accounts, to take everything you got. If there's for the living will, you want to have a new one. You don't want to give the your ex, soon-to-be ex, the power to pull the plug, and also have a new will, because if your will says everything goes to that person, a lot of people say, I don't want it to go to them. Some people goes, that's the last person on the planet I want to get anything to. The person that I am divorcing because they did this bad thing or that bad thing. Okay. The next document we're going to talk about is the Living Will Advance Directive. With the Living Will Advance Directive, that's think of the Terry Schiavo case, the Carrie Ann Quinlan case. Someone's in a hospital, irreversible condition. There's no hope for them. They're not going to open up their eyes ever again. So you're giving instructions to hospitals and doctors saying, listen, if there's no hope for me again ever, I do not want to, be on life support, feeding tubes, this or that. But it got to be in writing. The whole Terry Schiavo cases, it wasn't in writing, and they went to it had to go to the Supreme Court because it wasn't in writing. So with the living will, what you're doing is you are in the first section, and we took language from the State Medical Society. This way doctors and hospitals were familiar with it. So section A, fluids and nutritions, to either withheld or provided. Most people, probably 85% of people say, hey, if there's no hope for me, then I don't want to be having feeding tubes put in me. It's different where, it's not saying, hey, I don't want to have, if I have a heart attack, just, don't do anything for me. It's where, someone's in an irreversible condition and can't talk for themselves. So nowadays, 85% of people are saying, listen, if there's no hope for me ever, I don't want to be on feeding tubes where I'm brain dead. The next section deals with directives as to medical treatment. And I sometimes say artificial machines, and being kept alive, respirators, etc. Again, it's not saying, someone has COVID or pneumonia, they're just going to say, okay, tough luck. It's more, there's no hope for people. And nowadays, 99% of people say, hey, if there's no hope for me, then pull the plug. I don't want to be a burden. And again, the the living will is a document for your family and your loved ones, not you, because you're basically already gone. Um, and I remember one time when a doctor asked me, the final question. It was someone that did not have a living will, but I was their person on the power of attorney. He goes, doctor goes, okay, should we remove the life support today? And I remember saying to doctor, geez, doctor, I feel bad, basically to end the person's life. Now, the right call is for someone who's 92 years old, that's never going to regain consciousness, never open up their eyes again. But you hate to be the one to say, okay, call the funeral home today. So therefore, you feel bad. I couldn't even do it for my dog. So therefore, when you do the document, you're doing it for your family and for your loved ones, not you. The living will also typically has an organ donor, yes or no. Even if someone already, signed it with motor vehicles, has it on a driver's license, we try to encourage more and more people to have this way. It's clear what someone wants. And interestingly, I went to a program put on by the NJ Sharing Network. That's the entity that deals with organ donors in New Jersey. And I said, what's the maximum age to be an organ donor? They said there is none. I goes, well, what's good on an 85-year-old guy? And he said, nothing. He goes, skin and corny. He goes, well, I never thought about that. If I was burned in a fire, I'd rather have old guy skin than everything that got burned off me. And then I said, what illnesses disqualify someone from being an organ donor? Because for the giving of blood, the disqualification list is 8 pages long. They said at the time, the only disqualifier was HIV positive. Let's see. And now, interestingly, that was taken away because someone who's HIV positive can donate an organ to someone else that is HIV positive. So, if someone's the situation came in, someone's partner, is going to die without a new kidney. Someone says, well, listen, okay, I got 2. I'll give one of mine to save this person's life. So a lot of the thing of with organ donors, you're saving someone's life. Let's see now. So we went through the 3 main documents: the will, power of attorney, and living will, also known as advance directive. Now, after for healthcare, medical proxy, after you sign your living will, it is a good idea to also scan that, email it to yourself, email it to your family, email it to the doctors so that they have it on their records. Executor duties, probate in New Jersey is easy. The surrogate's officers are still closed as of March 2021. So we help the people. We fill in the paperwork to file the will. So we prepare the paperwork. We fax or email the surrogate's office a copy of the will, copy of the death certificate, the form. Surrogate's office sends us the paperwork back. The person signs it in our office. That's probably the only time we see people in our office. Then we have to send by certified mail or UPS the original will, original death certificate, the notarized forms, and check for about $150. Surrogate sends us the papers back. The executor then obtains a tax ID number, sets up a estate account. We work with them to sell the properties. The accountant does then we have to do in a New Jersey inheritance tax form and return and have that filed, even if there's no tax that's due, because it's still until we get it filed in New Jersey inheritance tax waiver, it's still a lien on real estate. And then typically the executor deals with liquidating assets, put in the estate account. Then the attorney prepares the release and refunding bond. And then that's signed by all the different beneficiaries in front of a notary. We file that with a surrogate, then everyone gets their money. Not that complicated. However, let's say someone gives the family a hard time. They've gotten their informal accounting. It's an equal split. everyone got a sign in front of the release of a funding bond saying what they're going to get and that they're cool with the executor. Sometimes you get someone who's a troublemaker. They go, no, I'm not going to sign it. I'm not going to sign it. Well, that becomes a problem because that means nobody gets their money. Nobody until everyone signs. But what we tried to do is, let's say if one person doesn't sign, the first letter goes out saying everyone has to sign and return it to us by, and we usually give a 2-week period. Because everyone wants to get their money. And in 2 weeks, if we don't get it back, we put out a letter saying, okay, we got it back from everyone except for this person. And then we put in a letter that, listen, we haven't gotten it from Uncle Wally who lives in North Carolina, or Brother Wally who lives in North Carolina. Unless Brother Wally signs this release and refunding bond, we have to go, the estate has to, no one gets their money. The estate has to go to an expensive procedure to file a complaint, to approve the formal accounting and do a formal accounting. So they're looking at spending taking 6 months, or because of COVID, it could be a year, and no one gets their money until then. So then we put in a letter. However, if Brother Wally signs it, then we don't have to go through all this and take the money out of the estate fees. And then we put his, Brother Wally's address and phone number, by the way, is this, and that's his phone number. This is his email. This way the family can lean on that person. So in a nutshell, that is wills and estates 101. Say my name is Ken Vercammen. I'm an attorney in Edison, New Jersey. Our office phone number is 732-572-0500. What we're doing now is estate planning, probate. So we always say if someone wants to hire us to help them out, we'll try to do the best job possible for people. A will that's done here in New Jersey is valid in any other state. So even if you move to another state, it doesn't mean that you have to rush out and get a new one done. All right. Okay. Thank you, everyone. And Ken Vercammen is now finished with his presentation. I'm going to ask that the library now bring in our financial planner, Dan Fabrizio.
Good evening. Can everyone hear me? Great. Good evening, everyone. My name is Dan Fabrizio. I'm a financial advisor with New York Life Securities. I've worked on Wall Street for 22 years. We're institutional investors with my clients. And now I like to say I work on Main Street where individuals like yourselves are my clients. I just want to talk about 7 of the most common retirement mistakes based on our experience. And maybe touch a little bit on the Secure Act. I'm only going to speak for like 10 or 15 minutes tops, and I can take questions at the end. Number 1, not planning your retirement with your life expectancy in mind. You have to stop using your parents and your grandparents as estimates for your life expectancy. The reality is life expectancies are increasing more than they were 30 years ago. The important part, I feel, is to rely on data, not hunch, and be careful not to be fooled by actuary estimates. There's nothing deterministic about life expectancies estimates. Number 2, not being smart about claiming Social Security. Some people are still taking Social Security before the full retirement age. This means that if you apply for Social Security before the full retirement age, you're going to receive a smaller monthly Social Security check for the rest of your life. If you have the financial resources and believe that you're going to live longer than average, generally speaking, waiting to take Social Security at a later age, no later than age 70, means that you will receive a larger check, monthly check, for the rest of your life. And depending on your personal situation, so to learn more about that, you probably want to check out the Social Security website. Number 3, taking a lump sum from a pension could lead to expensive mistakes. But thanks to annuities, it can help retirees meet their retirement goals with a guaranteed lifetime income stream. The lump sum payment is your only option. If you're able to receive a lifetime income stream from a current pension, it may be the preferable option depending on one's particular circumstances. Number 4, too much risk in your investments as one nears retirement. By taking too much risk with your portfolio when you may not need to, can dampen or reduce the retirement income you need to live on for retirement. So as you get nearer retirement, you want to get out of the aggressive investments, kind of like equities and stocks, and move towards the more conservative investments like bonds and T-bills. Number 5, buying life insurance as an employee benefit. While it's generally less expensive and easy to take the group term life insurance coverage from your employer while you're still working, this coverage typically goes away once you leave the company and retire. And if you're age 50 and older when you retire, it can get expensive to begin buying life insurance at that age. One option, the easy and too late option, is to buy a permanent life insurance policy when one is younger, in addition to keeping the employer group term life insurance benefit. But if you're 50 and older, there are still some whole life insurance products that, depending on your coverage goals one is seeking, can still help with retirement plans. Number 6, focusing on assets over income. One mistake I've seen is failing to switch your mindset from retirement savings to retirement spending when nearing or at retirement. The main purpose of saving for retirement is so that you have enough money to spend in retirement. So say if you have, say, $500,000 in your IRA, but in terms of living standards, what does that mean? And based on your spending needs and other income sources, how should your assets be allocated once you retire? Can you safely withdraw 3%, 4%, 5% of your IRA and let it last your lifetime? Here's the reality. It's hard to know what kind of standard of living one can have if all your assets in one type of product or account. Consider reviewing your situation with a financial professional that can help you with your retirement goals and your plan. And number 7, bank CDs. Older adults, when they retire, tend to store large amounts of money into bank CDs. Why? Because the bank recommends it. The downside of a bank CD is that if you lock your money up into a multi-year CD at the end of each year, the bank's going to send you a 1099 form with the interest you've earned, and you got to pay tax.
Hey, this is Ken Vercammen. I'm not sure if there's any sound.
Yeah, I think he kind of went on mute.
Okay, he
Trying
got
to get
muted.
him to,
I'm
Okay,
trying to
sorry.
get him off of mute.
Did you hear my last topic? Okay.
Nope, we heard nothing.
I think the last 3 points.
The last 3 points. I'll go
I
over them
think
very quickly.
you were on like I think it was 8.
Yeah.
Point
So,
number 8. Did you
point
hear
number-
about buying life insurance? Yes or no?
No.
Okay, we'll start from there. That's the last 3.
All right.
Buying life insurance as an employee benefit. While it's generally less expensive and easy to take group term life insurance coverage from your employer while you're still working, this coverage typically goes away once you leave the company and retire. And if you are age 50 and older when you retire, it can get expensive to begin buying life insurance at that age. One option, the easy and the too late option, is to buy permanent life insurance when you're younger, in addition to your employer's group coverage. But if you're 50 and older, there are still some life insurance products out there, depending on your coverage goals one is seeking, that can help you with your retirement plans. Number 6, focusing on your assets over income. One mistake I've seen is failing to switch your mindset from retirement savings to retirement spending when nearing or at the retirement age. The main purpose of saving for retirement is so that you have enough money to spend in retirement. Say you have $500,000 in your IRA, but in terms of living standards, what does that mean? And based on your spending needs and other income sources, how should your assets be allocated once you retire? Can you safely withdraw 3%, 4%, 5% from your IRA every year and let it last your lifetime? Here's the reality. It's hard to know what kind of standard one can have if all your assets are in one type of product or account. Consider reviewing your situation with a financial professional that can help you with your retirement goals and plans. And bank CDs. Older adults, when they retire, tend to store large amounts of money into bank CDs because the bank recommended it. The downside of a bank CD is that if you lock your money up into a multi-year CD, at the end of every year, the bank's going to send you a 1099 form with the interest you've earned, and you have to pay taxes on that interest, but you can't spend that interest. The better option that's available, and that's if you're going to lock your money up for a few years, is open a multi-year annuity instead. Here's why. You'll probably get a slightly better interest rate, and the most important feature is that the interest you earn in your annuity is tax deferred. This means at the end of the year, you will not receive a 1099 and have to pay taxes on the interest you earn and cannot withdraw. You will only pay taxes when you take the money out of the annuity once it expires, or if you roll it over into another annuity, it remains tax deferred. And a new option that annuities have are liquidity, where you can take money up to 10% of the balance out of the annuity every year without any penalty. So there is liquidity in annuities, which is different from a bank CD. And the last topic I just wanted to touch on briefly is the Secure Act that came out in 2019. The most important feature, I mean, there were many features of the Secure Act, but the one that caught everyone's attention was the elimination of the stretch IRA. Basically, if you inherited someone's IRA back before the enactment of the Secure Act, you were able to take that IRA and let it sit on it till you were ready to retire. And it could have been 20 or 30 years down the line. Now, with the Secure Act, if you inherit an IRA, you have to liquidate that inherited IRA within 10 years. So if you're older and in retirement, that may not be a bad thing. It enhances your current retirement proceeds. But if you're much younger, obviously you're taking money out and you're going to have to pay taxes on that money. But there are still some strategies available that if you're young enough and you don't have a retirement plan, you can actually convert this into your own personal retirement plan. So that's basically all I have to touch base on. Again, my name is Dan Fabrizio. I'm a financial advisor with New York Life Securities. I'm also a licensed agent of a New York Life Insurance Company, and I'm licensed in New York, New Jersey, and Pennsylvania. And if anyone has any questions, I'm more than happy. I can be reached at 609-213-3950. And I don't know if there's any other questions out there. There's a moderator.
This is Ken Vercammen is back. Thank you, Dan Fabrizio. So one of the questions I talked about if the attorney get retired or close their office, anyone can go to any attorney they want. Just like if an attorney did the will and that person passes away, the family can go to any attorney they like to be the executor. So no one's a prisoner to the prior attorney. You pick who you like, who you want. Another question deals with what we call debts of the person who died. So typically, the family is not liable for debts. However, do not become the executor or administrator of a bankrupt insolvent estate. You're sticking your head in a bee's nest, because why do you want to be aggravated just so credit card companies, like mortgage companies, etc., can just make your life miserable, etc. So typically, before you rush off and become the executive administrator, is there money in it for the beneficiaries and for you? Why buy yourself a headache? Now, there is a thing called the Doctrine of Necessities, where a spouse could be liable for certain necessities of their spouse that passed away. An example is, life-saving medical bills. Let's say, technically under the statute, a hospital could sue someone or a spouse, but the kids aren't liable. However, let's say if there was what's called fraudulent conveyance. Let's say the person had $100,000 in debt, and the person knew they were going to pass, and they said, okay, I'm going to transfer all my money to my kids and screw all these creditors. And they have, under the Fraudulent Conveyance Act, fraudulent transfers, they can go after the person that received these monies. Even if it was listed as a gift, they could chase the person for those monies. And I think those are the only two questions that are there. So I think we are good for today. My name is Ken Vercammen of Edison, New Jersey. And our website is njlaws.com. Woodbridge Library, any last things to go over?
No, nothing from me. Just I will be following up with everybody, emailing out the information that Mr. Vercammen and Mr. Fabrizio mentioned in this seminar tonight. And I also want to thank you both for, speaking at our library and giving us this information. And I'm pretty sure everybody appreciated that. Yes, Trish, that will include their contact information, the website, all of that, how to get in contact and contact. Oh, and also the information about the $200 consultation fee. I will remind everyone in that email as well. It's waived, yes. Yeah. But yep, that's it from me. But thank you all for, again, have a good night.
Thank you. Bye-bye.
Thanks.